Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. Please call the case.
Good morning, Your Honors. The case before the court this morning is the case entitled In Re Burton Corporation Conditional Use Act 250, case number 23AP315. Representing appellants Lawrence Smith et al. Is attorney Sarah Starr. Present with attorney Starr is attorney Jim Dumont and attorney Colin McNeil. Representing the appellee Burton Corporation is attorney Jeffrey Hand. Present with attorney Hand is attorney Malachi Brennan and attorney Kimberly Sturdivant.
Okay, thank you very much. Good morning again, counsel. Come on up, please. Please, for the record, introduce yourself and identify your client.
Good morning, Your Honors. I am Sarah Starr, and I represent the appellants, the Citizens for Responsible Zoning Group.
Thank you.
The appellants are all residents of the residential neighborhoods that would be directly impacted by this proposed Burton Higher Ground venue in the city of Burlington. I want to start by highlighting the Environmental Division's statement on page 4 of its decision, where it stated, in the performance space, there would be bars where alcoholic and other beverages would be served. But the city's conditional use ordinance allows that performing art centers may contain accessory space for the preparation and serving food and beverages, including alcohol, provided that the accessory space is less than 50% of the entire establishment. Interpreting accessory space to mean the very same space as the performance space with the overlapping square footage is a clear legal error in this case that requires reversal.
Ms. Starr, is the complaint the permit itself, or is it the conditions of the permit? The conditions such as the alcohol serving? Or is it the granting of the permit in general for the alternate use?
It's the granting of the permit without showing that the accessory space, without a showing that the alcohol will be in an accessory space, and without a showing that the space would meet the 25%. So treating bar counters as accessories, like enhancements on the principal space, turns the word space into a mere surplusage. And that could not have been the intent of the city council.
But didn't the town development manager, town manager, specifically testify that the accessory space was added to the town's ordinances because of the food and drink issue, and that was the intent in creating that language?
So the intent in creating that language was to allow, because there is no conditional use, that bars are not allowed in the district at all. And so the intent was to allow food and alcohol, but the intent was not to functionally turn the entire space into a bar. The intent was to have a separate space, maximum of, let's say, 5,000 square feet, where the patrons would have to exit the performance area.
Where's that language in an ordinance or anything from the city that indicates it has to be a separate space?
Well, I mean, the word accessory space, just in its plain meaning, and the only other time that the DRB interpreted it was in the arts right case, where it was interpreted to mean the separate square footage. And just in general, when referencing accessory spaces throughout sort of zoning law and other jurisdictions, it's always referring to additional square footage. It's not, accessory spaces never refer to enhancements with furniture, decoration, or fixtures of the principal space. And so and it's not, it matters in this context because if patrons have to, I mean, the patrons would still be able to enjoy food and beverages during a performance. However, by having to make a choice to leave the principal space, either maybe beforehand, get their beverages and food, come back in, or to wait till, let's say, a set break, that's going to enhance public safety and it's going to maintain the purpose of the performance venue as being just that, a performance venue. It's not just going to be a place where you can listen to music and drink as much as you want, because you have to make a choice to either stay and listen to the music or to go get more alcohol. And you might not want to do that. You know, you might do that once or twice, leave and get more alcohol. But you probably, if you are actually interested in the performance, you're probably not going to do that 6, 7, or 8 times.
Isn't it the language preparation and serving that we're having to wrestle with here?
It does talk about preparation and serving. And so, I mean, the appellant's brief does not focus on consumption or where the consumption is going to occur. But
Well, consumption isn't the word that's used, and if it was used here, it would certainly be an easier analysis.
right. And we're not suggesting that patrons can't bring their food and beverage into the space. But the preparation and serving of alcohol has to be in a separate accessory space. And I think that that's really the only reading of the ordinance that's correct.
Well, the appellees are arguing that serving is restricted to what happens over the bar.
I mean, I
Isn't
think
that a reasonable approach to that?
I don't think that the serving stops because you have to pass the beverage over the bar to the person who receives it, and that's part of the act. And so I think that the serving, and again, it's all within the same square footage, and the patron can stay in the same space listening to the music and just go to the bar and get beverage after beverage after beverage without ever having to, make a choice. And I think that having to actually go to a separate space and get another beverage, if that's what you want to do, is consistent with public safety. And it's also going to ensure compliance with the 25% rule, because the main area is going to be your performance space for people who want to be listening to music.
Is there table service in this record? Is that anticipated?
No, there's no suggestion that there would be table service. But many bars don't have table service. I mean, if the bars could just simply be, under this interpretation, there could be bars like all around the room where you could just get, and then just a person with a guitar in the middle. And so if the idea of the ordinance, which the legislative history shows, is to make sure that this is primarily a performance space, then having the preparation and service of food and beverage in a separate accessory space is consistent with the language and consistent with the legislative intent.
When we look at an ordinance, we consider the town's interpretation of that. And one of the things we consider is whether there has been a different interpretation applied to somebody else or some other entity. And is there any evidence of that here, that there's been application unfairly between different people seeking these venues?
The only one that I can think of in this district, in the ELM district, is the Arts Riot, and that did have a separate accessory space. There were not bars placed throughout. The other higher ground facility, which is in South Burlington, is similar to this in that there's bars within the performance area, but that's not in a district that doesn't allow bars. And so the difference here, that might make this uneven or seem, different from other venues in Burlington, is that the ELM district is a district that does not even allow bars as a conditional use. And so if higher ground wants to have its enhancements in the performance area, it is free to do so, just not in the ELM district. It could go into the downtown district.
Mr. It sounded like the board included a lot of conditions on Burton to make sure that public safety and neighbor safety was somewhat preserved. Doors closed, limitation on tailgating, traffic control issues and the like. But you think it needs more than that?
I think that some of the measures were satisfactory, and I think that's reflected in our briefing, but we didn't brief the doors, the issue with the doors, because there was a condition in place for that. But the main problem with the conditions is that with regard to the traffic noise, I think what the environmental division overlooked, because it made a lot of findings about why it would be attractive for concert goers to park off-site.
Was that the bike issue? Is that for the bike?
Not for bikes, but just for cars, that cars would sort of go into a side street and park so that it wouldn't have to avoid, so they would avoid traffic backups at the one-lane bridge or in the parking lot. And so there were prohibitions put on off-site parking. And the court made a specific finding that off-site parking would basically turn these public streets into having the same noise level as the parking lot, which is to go from an area with very little noise to being a 426 car parking lot is a drastic change, not an incremental change. And so that finding, especially in light of all the findings about how close these houses are to the road and to each other, I think was really significant in this case, especially because even if the parking conditions that the court added with tow trucks did mitigate that, which for noise purposes, we're not taking the position that it did mitigate it, because it actually, tow trucks add noise. But the conditions that make people want to not park at the Burton site would persist. The traffic at the one-lane bridge, all of the reasons why people might want to park on a side street. People aren't gonna, if there's plenty of parking and not a traffic jam, or you're at the place where you're going, you're just gonna go there and park unless you, I don't know, unless you like want to get your more steps in for the day or something like that. But those conditions persist, and I think the court's decision acknowledges the reality that those conditions persist, but then didn't find that it would have an adverse impact on the area, which is just the legal conclusion is not supported by the court's findings about the traffic situation that would exist there. So if there's no other questions, I will reserve the rest of my time.
All right, thanks very much. We'll hear from Counsel for the appellee, please. Are you dividing time? Counsel?
No, Your Honor, we are not.
All right, then please introduce yourself and your client to the record.
Yes, good morning, Chief Justice. May it please the court, my name is Jeff Hand from SRH Law. I'm here representing Burton in this matter, the applicant. Burton, together with Higher Ground, have been working on repurposing this industrial manufacturing space in Burlington's Enterprise and Light Manufacturing District for over 5 years. There's no question that the proposed Performing Arts Center is an allowed conditional use. Indeed, the city of Burlington updated its zoning ordinance before the present application to expressly allow this type of use in the district. The application here was supported by extensive expert analysis, was reviewed by the Burlington Development Review Board, the District Commission, Act 250 District Commission, and the Environmental Division, all of which found that the design of the facility as conditioned met all applicable state and municipal requirements. The issues before this court now are just 3 narrow ones, which the court correctly concluded after an extensive trial, almost a week-long trial, taking evidence. The court correctly found that the application is for a performing arts center and that the bar space meets the definition of accessory space in the CDO. The court also correctly concluded that the plainly audible language in the Burlington Noise Ordinance does not meet the definition for a performance standard in this case and cannot be applied prospectively, which is consistent with the city's longstanding practice with respect to that ordinance. And finally, after hearing credible evidence and lay witness testimony on project noise and on noises in this heavily industrialized area, including consideration of noise from traffic departing the site, The court correctly concluded that the project would not generate noise that is out of character with the area or otherwise unduly adverse.
What about the serving of alcohol, Mr. Hand?
Yes, thank you, Justice Cohen. I want to address the accessory space and accessory use issue. The court correctly found there that this project did meet the definition, the specific definition for accessory use contained in the definition of a performing arts center. The appellants have made a number of arguments related to the separate accessory use language in the ordinance, but that doesn't apply here. Burton has not applied for an accessory use permit. It's applied for a permit for a performing arts center, which includes a specific allowance for the preparation and service of food and alcohol.
But on this issue, this is the one I want to talk to you about. Don't we owe deference to the city under Lathrop as to how they've interpreted their own ordinance in the past? And isn't there a record here of them having interpreted this language to include consumption?
Yes, thank you, Mr. Chief Justice. I think the court does owe deference to longstanding consistent interpretations by the underlying municipality. In this case, there's ample evidence about the purpose of this language in the record, the legislative intent, as Justice Carroll has pointed out. But with respect to the consumption question, the one situation where this has been applied is the Arts Riot case. In that case, it was a very similar situation where there's an area for preparation and service, and then drinks could be consumed throughout the space. There was no dividing or separate space. The language in that permit, as the zoning administrator noted in his deposition, incorrectly referred to consumption. That term, consumption, as Your Honor pointed out, is not in the ordinance itself. So the analysis really is first start with the plain language of the ordinance and apply that. If it's unclear, then you can consider consistent longstanding interpretations. And I think you'd find in the record, looking at his deposition, that even in Arts Riot, they did not intend to consider consumption. It's limited under the ordinance to preparation and service.
So is your argument no deference? Is that what you're saying?
No, not that there's no deference, but that in terms of statutory construction, you start first with the plain language. And if the plain language is clear, then you apply the plain language. And here it's preparation and service. If you found that ambiguous, you'd then also consider deference to longstanding interpretations. And even if you get to that point, I think you would apply the record here, which indicates that the municipality did not intend, it did not functionally interpret consumption to be part of that ordinance. Makes sense. This question about whether it needs to be a separate space, as Justice Carroll noted, there is no requirement that it be separate in the ordinance. So looking at the plain language of the ordinance, what Burton has proposed and what the court found is consistent. And I would say that's also a factual question. The court here looked carefully at what the space was for preparation and service and found very clearly that that will happen in 10 by 20 areas around the bar. We're not just talking about the bar counter, as appellants keep arguing. We're talking about the bar preparation and service area. There is no table service in this facility. So the areas in which food and drinks will be prepared and served is quite limited. In this instance, each bar was less than 1.7% of the square footage. So even with 3 separate locations for that, we're well under the 50%, as the court found, and this court should defer to that, as it's not clearly erroneous. I want to turn to the plainly audible question as well that's presented. That section of the Burlington, the plainly audible language comes from Burlington's noise ordinance, which is a separate section, separate ordinance. The court below found that the plainly audible language did not meet the definition for a performance standard in state law, which is 24 VSA 4414.5. That state law is very clear. And as we know, Vermont is a Dillon state rule. So municipalities only have the authority to act where it's granted by the legislature. And under that statutory requirement, performance standards need to specifically describe the level of operation that are acceptable and not likely to adversely affect the use of the surrounding area.
What's confusing about this is that she left in place enforcement. And I understand, and I think it's clear that the authority that's delegated to the municipality under the law for enforcement purposes is somewhat more broad than it is under 4414. But I think that isn't a inherent ambiguity in the trial court having made this distinction, Mr. Hand?
I don't believe so, Mr. Chief Justice. There's a statutory requirement for a performance standard that could be applied before the fact. So you're talking there, looking at whether the applicant has reasonable notice, and it defines specific things that you could present evidence on and show compliance with. And as the court found, this doesn't meet that standard. When it comes to enforcement, as you noted, Your Honor, there's greater discretion. Once the facility is operating and there's prosecutorial discretion as to whether facts on the ground show compliance. And I note here, there are very comprehensive conditions already imposed on this facility with respect to monitoring and ongoing compliance separate from that. But that is a discretionary act of someone on the street, then in this case, a police officer being able to exercise their discretion to determine if it's consistent with the statute or the ordinance. But I do want to note also, it's very common in Burlington, and the record shows that Higher Ground here would pursue what's called an entertainment permit as well, which is an express expressly carves out those types of activities from the plainly audible standards.
But the thing that's confusing is that we've got the same language that would apply to both functions, if you will. It seems to me that this is a creation that lays the groundwork for, well, for one thing, for a lot of litigation, I would expect.
And I think that's why, Your Honor, the court imposed a number of conditions related to sound from the facility. And to be clear, the plainly audible standard only applies to music coming from the facility. There's a separate condition that requires ongoing monitoring and then requires the facility to take action if it's above the established standards. And to Your Honor's point earlier about deference to the municipality, the record is very clear that Burlington never applies the plainly audible language in a manner at the permitting of the facility. So when there's a conditional use analysis taking place for the permitting of a project, you look at the conditional use standards and don't apply that plainly audible language. And that is longstanding and is documented through numerous decisions in the record.
Mr. Hand, can you explain to me the credible evidence that was introduced at the trial regarding the lack of audible issues or lack of having an adverse audible effect?
Yes, certainly. There was extensive expert analysis of this issue. So it started with background monitoring locations, two in the vicinity of the project to monitor the existing background levels. That documented that, as would not be surprising for a heavily industrialized area, the existing background noise is actually quite high. From HVAC units, from buses and trucks traveling regularly, including from regular traffic in the area. There are manufacturers who have shift changes, including late at night. So there's ongoing loud noises in this area already. So that background monitoring documented that. And then Burton's sound analysis expert did a comprehensive modeling of the project sound. All the sounds coming from the project, both concert-related noise, building-related noise, so HVAC, and noise associated with traffic at the facility and departing the facility. All of that documented that both the music specifically, the music level would be well below background levels, the closest receptors, including residences in the area, as well as the overall noise being below background level. So based on that finding, although the court didn't apply the plainly audible standard, the court actually found in a footnote that even if it did apply, all those existing background noises would mask the music noise from this project in those areas.
So is it your understanding that no neighbor would be able to hear the music until closing time?
I don't think that's the suggestion, that there may be points in time when music could be audible. But again, turning to the court's analysis of this plainly audible standard, one of the things she pointed out is the performance standard under state statute must only apply to things that would result in an adverse impact. And the finding here was, because the music was likely below background, that even if it was perceptible at some times, it's not to a level that would be adverse. And that's one of the reasons that applying it prospectively really doesn't make sense in this case. I'll return briefly with my remaining time to the last question about analysis of traffic departing the facility. I think the appellants have made suggestion that this issue was not considered by the court, and we pointed out in our brief that it was. And I want to point the court in particular to the record site AV1-133. The court there summarized her findings, the court's findings of the expert analysis, and summarized saying, thus his conclusion was that music from concerts, and I underline here, and post-concert vehicles leaving the site would not perceivably increase the level of noise at the residence that is most likely affected by concert noise, and that all other residences would be either the same or lower. So there was very specific consideration of this, and it was in two ways. One, in the very conservative modeling that was done of project-related traffic noise in the parking lot after the concerts, as well as record evidence testimony offered by the expert, in that case, considering car pass-bys at residences on roads leaving the project location. And in that case, they specifically found that those levels of noise would be below any established standards with vehicles passing by residences. So we dispute that that issue was not considered. It was very clearly considered, as was the frequency issue. Again, the cases appellants rely on with respect to considering the frequency of events really turn on different circumstances. You're looking there at cases where there are very high decibel truck traffic, think heavily loaded quarry trucks that are departing. And in those cases, this court has said you should consider some of the frequency impacts of multiple events like that. We have a very different situation where the court here found we're talking about regular, consistent sounds from passenger vehicles that are like the sounds already in the area. But even with that consideration, the court did impose a limitation of 12 events per year that could happen, that could end after midnight. So considering the frequency of these kinds of events wasn't expressly incorporated into the conditions the court imposed. If there are no further questions, I will conclude.
All right. Thank you very much.
Thank you.
Thank you. How much time does the appellant have, please?
Appellant has 3 minutes and 24 seconds remaining.
Counsel.
So just to be clear, the Arts Riot decision did involve separate space, require separate space for preparation and service of alcohol. Second of all, the appellee talked about the noise levels dying off at night in the area. I mean, sorry, so the noise levels were already very high in the area, but the evidence showed that at night it was very low noise. And so the additional 426 cars passing by would significantly increase the nighttime noise.
Where did that come from in the record? Your clients didn't call an expert on that issue, did they?
They did not, but the appellee's expert testified that these car pass-bys of the houses, and we're talking about 400 cars, that they would reach nearly 60 decibels. And that is the health, that is right on the cusp of the World Health Standard. And so Burton simply did not meet its burden to show that there would not be those adverse impacts on the residential area. I wanted to touch briefly on the enforcement versus the zoning function. Zoning laws are part of the police power, and it is incongruous to say that an ordinance is unconstitutional for zoning purposes, but not for enforcement. It would lead to uneven enforcement. And as your owners pointed out, a lot of litigation certainly noise complaints could be easily defended by pointing to this decision or this court's decision if the ordinance was struck down on vagueness or overbreadth grounds. And so I would ask that the court reverse that portion of the decision. And in conclusion, this project would just represent a sea change for this district, which is a quiet residential area. It would go from a district with no bars to having probably one of the largest functional bars in the city, maybe in the state, in violation of an ordinance that was adopted to ensure that performing art centers are just that, performing art centers, and not places where alcohol is served, where music is also played. And the area would go from an area with very low noise at night to one with periods of constant vehicle noise, with vehicles being operated and occupied by the patrons that have been able to drink pretty much an unlimited amount of alcohol while listening to music. So the appellants therefore ask your honors to reverse the decision of the Environmental Division.
Okay, thank you very much. Thank you both. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for